Hello, folks. Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So, I have often said that sometimes lawyers will do anything for a client they really like or are in other ways enamored with them. And I think we have a pretty good example of that today, given the latest debacle in the Depp versus Heard versus insurers case. I'll have more on that in just a moment. As I have frequently observed, insurance companies love to explain to you how much they are going to protect you. And then when the chips are down, they come in and stick a knife in your back. The reason you buy insurance is to protect you and to protect your assets. And you buy that insurance in many respects because you don't know what's coming. And it's often difficult to predict what is coming. But you have to be, generally speaking, on the side of the angels for insurers to come in and help you. And Amber Heard is figuring that out in a very painful way for her. So, some of you may know that the two insurance companies involved, Travelers and New York Marine, got into a tiff in July about who should cover the expenses and lawyer costs and judgment in the Amber Heard case. And so the companies sued one another. And then immediately thereafter, New York Marine also sued Amber Heard. Now, the lawsuit was filed on July 11th. On October 31st of this year, Amber Heard's lawyer filed a stipulation between her and New York Marine that gave her until November 21st to answer the lawsuit. Why is that important? Well, we'll get to that in just a moment. Also, at the end of the month of October, Ms. Heard and the parties got together. They had what's called a meet and confer. It's required by the rules. And they got together with regard to scheduling issues. In other words, when you have a lawsuit, particularly a big lawsuit, one that's going to be important for court watchers, you will often have them decide as a group how they want to handle discovery, when they want to have dispositive motions, and that sort of thing. And so they got together and they had this, and when it was filed with the court, Ms. Heard sort of dropped a bombshell. And here's what that bombshell said. Ms. Heard respectfully submits that it's premature to enter a scheduling order for two reasons. First, there is no diversity of citizenship. Ms. Heard was not a resident of the United States when New York Marine filed its lawsuit, and it's not now a resident of the United States. Therefore, this court lacks jurisdiction. Well, resident is not the proper term. I would hope that her lawyers know that. Although, frankly, Ms. Heard has had a really bad record of hiring lawyers who are just not very good at things. Now, in the order, or in the document that was filed, they cite this case, Louisiana Municipal Police Employees Retirement System versus Wynn. And they quote, because the defendant is a United States citizen that has no domicile in any state, she is stateless for the purposes of 28 U.S.C. Such stateless status destroys complete diversity under Section 1332A3. Now, they put a quote in there, but that isn't actually what the case says. It later says cleaned up, quoting Newman Green versus Alfonso Lorraine. So let's look at that Louisiana municipal employees case from the Ninth Circuit. The interesting part of that is that it says the shareholder's complaint alleges federal jurisdiction exclusively under 28 U.S.C. Section 1332 Sub A, Sub 2, part of the diversity jurisdiction statute which covered suits between citizens of a state and citizens or subjects of a foreign state. The Louisiana case doesn't even concern what we have here between citizens of the United States and citizens of a diverse state. It's not on point in that regard. It cites this Newman case, and let's look at the Newman case. Here's what the Newman case says. In order to be a citizen of a state within the meaning of diversity statute, a natural person must be both a citizen of the United States and be domiciled within the state. See Robertson versus Cease. The principles in it are still the same. You can essentially be stateless, even though you may not necessarily be someone who doesn't have a domicile. So let's talk a little bit about diversity jurisdiction. Diversity jurisdiction requires complete diversity. So if I buy a Ford Motor Company vehicle from my local Ford dealer, which happens to be Sons Ford, if I buy my car from Sons Ford and the car has a product defect and I get injured in it, and I sue Ford Motor Company, I am diverse because Ford Motor Company is domiciled in Delaware. That's where it's incorporated. And it has another corporate location in Michigan. So that's pretty clear that there's diversity of citizenship, and because there's diversity of citizenship, Ford can remove the case, if it's filed in state court, to the federal court in the state where the lawsuit is filed. But if I want to be clever and I have a belief that something that the Sons Ford people did caused the defect to be worse, I can join them as a defendant, and because they are in the same state with me, the two defendants are not of diverse citizenship with me, and there's no diversity. The case stays in state court. So this leads to a whole lot of game playing in federal court and in state court in order to ensure that you either do wind up in federal court or don't wind up in federal court. Diversity requires complete diversity. So in these cases that they're talking about, what has happened is the person that they're suing is not a citizen of any particular state. In the latter case, the Newman case, they were from Venezuela. They were domiciled in Venezuela, even though they were a United States citizen, and for that reason, they didn't have a state, meaning a state where they lived in the United States. Their diversity could not be established. Now, we'll get to that in a little bit with regard to how this all shakes out, but the bottom line is you can avoid diversity jurisdiction by not having a domicile in the United States. So, let's take a look at a case that talks about when diversity jurisdiction is established, because that's the key question. The key question is not whether Amber Heard is today flitting off to Spain and London and points on the European continent. The question is, what is her domicile, or more importantly, what was her domicile on July 11th? Because that's the date that the lawsuit was filed, as you can see here. So here's what I found in one case that I thought was pretty interesting. Federal jurisdiction based on diversity of citizenship requires that the matter in controversy be between citizens of different states. For purposes of diversity, a citizen is a citizen of the state in which he's domiciled. And then it goes on to say, a person's domicile is a place where he has a true, fixed home and principal establishment to which, whenever he is absent, he has the intention of returning. Domicile is determined as of the time the suit is filed, and once diversity jurisdiction is established, once it attaches, it is not lost by a later change in domicile. This case was filed on on July 11th. Now, I don't have any evidence at this point where Ms. Heard was on July 11th. whether she had a home in the United States, whether she was renting someplace in Virginia, whether she had sold her property in California. All of these facts will be relevant when the court works to determine the diversity of citizenship in this case. But here's the really interesting part. She put off having to answer or otherwise defend until November 21st. Basically enough time to give her time to sort of set up this defense. When New York Marine filed this case, in paragraph 7, they stated as follows: Heard is, and at all times herein mentioned, was an individual who is a citizen and resident of California. So they have pleaded diversity jurisdiction. It's in the record. It is up to Amber Heard and her lawyers to defeat jurisdiction. She has to defeat that by showing that her domicile was not California, and that, or for example, that it was New York, where New York Marine is headquartered. Those are the two ways she can beat diversity of jurisdiction, or she can show that she really was domiciled in a foreign country. But just because you are living somewhere else, residency and domicile are not the same thing. And the cases are very clear on that. Now, if we look at the summons that was issued in this case, the summons was issued in August of 2022, and it was executed on August 31st of 2022. And it was received by counsel for Amber Heard, as you can see on this slide. So summarizing, let me put it this way. Is it possible for her to beat federal jurisdiction in this case? It is possible, but it will be up to her. She will have the burden of proof to show that she is not a domiciliary of any state in the United States and is in fact a domiciliary of a foreign country. It is not probably going to be enough to show that she is simply vacationing there or a resident there or traveling there, because eventually she will return to the United States. She's a starlet. She makes her money in Hollywood, California. And as a result, I strongly believe that's probably going to wind up being her domicile in this case. I can't fault the lawyers for trying this. It's a novel approach, but I would not have done it. It begins to look like gamesmanship, and the last thing you want to do in front of a federal judge is look like you are playing games. I wish I could go into more depth in this video, but I can't. So I'm going to pick up tomorrow on the state of play in this case, the different positions of the litigants in the case, and also where I think eventually this will come out in the event that she is successful in avoiding federal court jurisdiction. So thank you very much for watching. I greatly appreciate your patronage on this channel. And until tomorrow, find somebody to be kind to and have a great day.